So good morning, good afternoon. So it is lunchtime in the Netherlands actually. My name is Aurélien Lorange, co-director with Miss Urbanova of the Quarks Foundation. Together we'll have this match. This is a starting moment for two teams who are competing in this group. So we'll of course let them introduce themselves, but just to tell that it's a pleasure, of course, to welcome as well former participants who are coach in this match. So I would like to give the floor to my colleague now, who will be the host for the match.
Thank you very much, Professor Lorange, and welcome again to our two participating teams. Welcome to the team joining us from Gaborone, University of Botswana, and also welcome to the team joining us from Durham, the Durham University debate team. I would like to just give a short technical logistical information for everyone. I'll be the time. My apologies. I'll be the host for this match. My colleague will be the timekeeper, so visual keys will be coming from his stream. And for everyone watching us live on YouTube, today's debate is indeed part of the group phase day 1, which means all the topics share the same theme of climate change, state responsibility, and environmental law. The two teams today received their topics 7 days in advance. They will be debating on whether or not international courts should have jurisdiction to impose legally binding climate action plans on states failing to meet emission reduction commitments. So after 7 days of preparation, we'll soon have the algorithm allocate which team will defend which position during the debate. But before we get to that part, it's time to learn a bit more about our participants. Starting with the Durham University, Mr. Sluchenkov, the floor is yours.
Hello, my name is Ivan Sluchenkov. I'm a first-year student at Durham University.
Thank you and welcome. From University of Botswana, Ms. Motsi.
Hi everyone, my name is Tlamelo Maite and I'm a third-year law student in the University of Botswana, and thank you for having us.
Thank you, welcome. From Durham University, Ms. Elish Nelligan.
Hello, my name is Elish Nelligan and I'm a second-year law student from Durham University. Thank you for having me.
Thank you and welcome. From University of Botswana, Ms. Mugomba.
Good morning and good afternoon, everyone. I hope I'm very audible enough. My name is Tontina Mugomba and I'm a level 100 student from the University of Botswana. I'm pleased to be here.
Thank you and welcome. We would also like to give consideration and thank you to the support the teams have on the back end. I believe from Durham University, big thank you for helping us also and for the team to join the ELSA Durham student organization. And for University of Botswana, the team is supported by coaches Chimalongo, Ms. Rosetilo, and Ms. Njonde. Ms. Njonde is, together with her fellow coaches, a former participant of the Hague Inter-University Law Debate in 2024. And we do also have her on the call today.
Good afternoon and good morning. And I just want to wish both teams from the University of Durham and the University of Botswana good luck. I hope you guys have an intellectually stimulating debate.
Thank you. Thank you for the well wishes to the teams. I will now pass the floor back to my colleague who will share his screen shortly for the allocation of positions.
Yes, now it is time to know which position will be supporting, defending during this match. So now normally you should see my screen with the wheel and the double flag and logos of your universities. So as you can see, there are two chances for each university, either to be in favor, either to be against the motion. So we'll activate now the wheel and we know which team will be in favor and will be starting the match. So this is Durham University will be in favor of the motion and then will be starting the match with the first introduction. As a consequence, the University of Botswana will defend the position against the motion. So concretely, it means that Durham University will defend the position that international courts should have jurisdiction to impose legally binding climate action plans on states failing to meet emission reduction commitments, while the University of Botswana will defend the position that international courts should not have jurisdiction to impose legally binding climate action plans on states failing to meet emission reduction commitments. So now you have 5 minutes to review your notes, and then we'll be starting with the introduction by the team from Durham University.
Thank you very much. Your time for final preparation is now over. We'll be starting the debate session by hearing the opening statements. Starting with the team in favor, Durham University, you will now have 4 minutes.
Can I confirm that first that I'm audible and visible?
You are.
Thank you. So I'll be starting in 3, 2, 1. Ladies and gentlemen, esteemed judges and members of the opposition, the climate crisis is here. Rising sea levels, devastating wildfires, and extreme weather events are no longer anomalies. They are our reality. Yet despite international agreements like the Paris Accord, states continue to evade these obligations and treat climate commitments as mere suggestions rather than binding duties. And it is for these reasons that I strongly propose the motion that international courts should have the jurisdiction to impose legally binding climate action plans on states that fail to meet their emission reduction commitments. This failure is stemming from one core issue: the absence of enforcement in international climate law. International courts must enforce climate action to ensure that states comply with their obligations. Without enforcement, agreements are meaningless. Without consequences, promises are empty. And without accountability, the world is going to suffer irreparable harm. Climate action is not just a mere moral imperative, it is also a legal obligation. Under the Articles of Responsibility of States for Internationally Wrongful Acts, states are accountable for breaches of international law. Climate inaction, which causes transboundary harm, falls undoubtedly under this framework. The Trail Smelter Arbitration established that no state may cause environmental damage to another. This principle was then reinforced in Urgenda Foundation and Netherlands, where a national court compelled its government to reduce emissions. If domestic courts can enforce climate action, then why shouldn't international courts do the same? When a state knowingly emits excessive carbon, harming its neighbors, it should be held accountable. The International Court of Justice already issues binding decisions on human rights and international law, and climate change should be no exception, considering the horrific effect that climate change will inevitably have on human quality of life, causing death, destruction, and a threat to health. Critics may claim that enforcement is impractical, but international law already has mechanisms for compliance. Take the Montreal Protocol, where nations have successfully phased out ozone-depleting substances through trade penalties. A similar approach could enforce climate obligations via economic sanctions, carbon tariffs, or reparations to climate-vulnerable countries. Moreover, the International Criminal Court prosecutes crimes against humanity. Given the catastrophic impact of climate change, then why shouldn't the deliberate destruction of the planet face similar legal scrutiny? If corporations can be fined for polluting, then nations failing to meet emissions targets should also be held to account. Beyond law, this is also a matter of justice. The world's poorest communities contribute the least to climate change, but they also suffer the worst consequences. Climate inaction violates intergenerational equity, the right of future generations to a livable planet. 50 years from now, how are we going to defend our inaction? Are we going to claim that sovereignty justifies climate change? We have a duty, not just to our citizens, but to humanity and the future. The ICJ has the power to issue binding rulings, and it must do so for climate cases. Honourable judges, the issue is not a lack of legal mechanisms, it is a lack of political will. International courts must bridge this gap by enforcing climate compliance and ensuring that states uphold their commitments. Without accountability, we will face an unlivable future. The law exists to protect and ensure justice, so let us use it before it is too late and not after. Thank you so much.
Thank you. Thank you for your submission. We'll now hear the opening statements in the against position. University of Botswana, you will now have 4 minutes.
I'd like to first confirm that I'm audible.
You are.
Okay, thank you. I'll be starting my speech in 3, 2, 1. Good day, ladies and gentlemen. As I had already introduced myself, my name is Tamela, and I'll be debating on the motion that has already been stated. Now, ladies and gentlemen, the first thing that we can both pick on is that we both agree that environmental issues are at a rise in this globe. But is the involvement of the international courts going to fix that problem? No, it is not going to fix that problem. That is why we are of the understanding that there is an increased amount of environmental issues. The introduction and the involvement of international courts will not curb the issue. Rather, the only way to curb the issues that are at hand is by addressing the issues from
My
the root cause of the
apologies.
problem, which is where
My apologies for interruption. My apologies for interruption of the University of Botswana's opening statements. There is currently an issue with your internet connection. I would kindly ask everyone to close their cameras, with the exception of the timekeeper. And I would kindly ask you to restart. My apologies again for interruption.
Should I close my as well?
Can you please try to say the first sentence again?
Am I audible?
Yes. Yes, you are.
Okay. I will be starting fresh in. Why is it a glitch? Okay. Okay. May I begin?
Yes.
Okay, I'll be starting in 3, 2, 1. Now, ladies and gentlemen, what we pick from government is that we both agree that environmental issues are at a rise. However, we are of the belief as team opposition that the involvement of the international court is not going to curb the issue at hand. Therefore, we are of the sense and we believe that addressing the issues from the root cause of the problem, which is in the countries themselves, is what is going to fix this problem. Now, ladies and gentlemen, we stand by the issue that the international court at this juncture is already dealing with way too much. We have wars that are going on. We have a lot of issues, international issues that are going on that the international court in itself is already dealing with. Now, ladies and gentlemen, the imposition of these legally binding documents by the international court is going to say that the international court should also take time to deal with the enforcement of these documents, which is what we're saying. Rather than involving the international court, which is already doing its part by instructing, which is already enough, we should also try to involve these countries in their own development by empowering these countries to become the countries that they're supposed to be, by empowering them by providing means such as education, by providing means such as funding, in order to get these countries to the utmost tip of the perk that they're supposed to be at. Now, ladies and gentlemen, we should know and understand that by imposing such a law that is going to, by imposing these documents, we're going to create a certain verge of a certain amount of inequality in these countries. Now, ladies and gentlemen, we should know and understand that these countries are not the same. These countries, there are countries that are more developed and those that are less developed than the others. Now, if we're going to be expecting a law, if we're going to be expecting that documents be if we're going to expect that these climate action plans are going to be legally binding on all of the countries, while we know that countries do not have the same resources as all the others, it is going to be a problem in that it's going to create the gap, or the gap that is going to be very difficult to bridge, which we could have bridged by what? By empowering these countries to begin with. Now, ladies and gentlemen, I'm from a country as Botswana. Now, ladies and gentlemen, you cannot compare my country with a country that is highly developed as the US. Now, ladies and gentlemen, if you're going to impose the same strict climate action plans on a country like mine, as opposed to the other, like a country such as the US that is already as developed as that. Now, ladies and gentlemen, that is going to create a burden on a country like us to try to make sure that we reach a level as that of the US, which is going to promote inequality by doing so. Now, ladies and gentlemen, what we stand by is that addressing the problem by imposing legally binding climate action plans on all of the states, rather than dealing with the problem from the root cause of the problem, which is in the countries themselves, by also doing measures or putting in measures of empowerment or education and funding in order to fix the problem at hand, but rather bringing in the international court to force the hands of these countries is not going to curb the problem that we need to curb at the moment. And with that, I strongly oppose the motion. Thank you.
Thank you. Thank you very much for your opening statement. We'll now proceed to the first round of rebuttals, starting with the team in favor, Durham University. You will have now 2 minutes for your first rebuttal.
Yes, okay. So do I need to turn on my camera or?
Yes, yes, we just ask to close the cameras for the sake of the Botswana team. Thank you.
Yeah, okay. Ladies and gentlemen, honorable judges and members of the opposition, I argue to assert that international courts should have power to enforce legally binding climate change actions, and I will rebut the argument proposed by the opposition. Climate change is a global emergency that knows no borders, and inaction by one nation impacts the entire international community. While historical responsibility matters and climate change is an emergency that everyone is involved in, requiring universal action uh, should should be necessary. International courts would enforce differentiated obligations, ensuring wealthier nations face stricter penalties while still holding all countries accountable. Without that legal enforcement, voluntary commitments often fail, as we can see it with the Kyoto Protocol's weak compliance. From the perspective of existential threat, the failure to act decisively against climate change poses a risk not only to individual nations but to the survival of the humanity. The Paris Agreement, while a monumental step forward, heavily relies on voluntary national contributions and lacks an effective enforcement mechanism. As we have already seen with Paris Agreement, which US resigned from in 2017, the time for voluntary measures has passed. What we need now is a legal framework capable of compelling all the nations to honor their promises. The problem of existential threat overlaps heavily into an issue of human rights. Right to life is threatened as climate change increases mortality rates from disasters, and right to health because of the widespread pollution, and so is right to property and livelihood. Uh, in in conclusion, the existential threat of climate change demands nothing less than a collective and enforceable legal response. As we can see in Urgenda Foundation and the State of the Netherlands, the Dutch Supreme Court upheld a ruling requiring the Netherlands to reduce its greenhouse emission by at least 25% by the end of the 2020. So we can agree that position of the international courts and national courts is for the universal approach.
Thank you. Thank you very much. We'll now hear the first rebuttal in the against position. University of Botswana, you will now have 2 minutes. I kindly ask everyone else to turn off their cameras again. Thank you.
Good afternoon, everyone. I hope you can hear me.
Yes.
You can hear me?
Yes, we can hear you.
Okay, that's fine. I'll be rebutting what has been said by Mr. Even. From what he talked about voluntary measures being put in place by the international courts. And for that, I would have to say that it would be so unfair to work with voluntary measures because mostly there are some countries that volunteer and African countries do not get the chance to be put in place to say their word and say what they want to do. They're just given the platform and they're just told what to do. So I'll be rebutting that point. And I also have another point which talks about implementation. Um, Even if international courts have the authority to impose plans, enforcing these rulings would be very difficult because states themselves they might refuse to comply and they could also be a lack of political will to enforce the penalties. Then I would also want to add on about sovereignty issues, right? Many countries bug the idea of an international body having a say over their policies, seeing it as an infringement of their sovereignty. So having international courts to impose what to do on other countries, that would be so unfair because most of the countries would not would not like to. Thank you very much.
Okay, thank you very much. Just a short reminder, again, for the remainder of the debate, yellow card indicates 30 seconds left, red card indicates the time is up. On that note, I would like to give now the floor to Durham University for their second rebuttal in the in favor position.
Thank you. I'll be starting in 3, 2, 1. Well, if I can actually mention, the opposition brought up the fact that many countries have unequal resources, and we don't dispute that. That's very much in agreement, which is why we have brought up the fact that it wouldn't be a uniform penalties. They wouldn't be uniform penalties imposed on all nations. Rather, it is important that we would have differentiated obligations that ensure wealthier nations face stricter penalties while still holding everyone accountable. It is also worth mentioning that that many developing nations are at more risk of climate change, and it is important for them that we also act. The opposition have brought up sovereignty quite a bit, and some argue that forcing compliance infringes upon this national sovereignty. But we have to remember that sovereignty is not absolute. When a nation's actions endanger global stability, whether through war, nuclear weapons, or environmental harm, it is the job of international law to intervene. The UN Security Council imposed sanctions on North Korea for nuclear weapons violations because they posed a risk to the global security. Climate change is something that displaces millions and destabilizes entire regions, and it is an equally urgent risk. Just as the world united against nuclear threats, we need to unite against climate change. We need international courts are the best avenue to enforce climate obligations while simultaneously respecting sovereignty. We aren't in dispute that national sovereignty is important. We aren't in dispute that not all countries have equal resources, which is why this is something that needs to be taken into account when we talk about what types of enforcement mechanisms the court would take. But it does not mean that there should not be any enforcement mechanisms. Thank you for your time.
Thank you very much. We'll now hear the second rebuttal in the against position. University of Botswana, you now have 2 minutes. Could you please try again?
Am I audible?
Yes, you are now. Thank you.
Okay. I'll be starting in 3, 2, 1. Now, ladies and gentlemen, team proposition speaks on enforcement and how these enforcements are going to be beneficial to the country, to the globe at large, and how it is going to be curbing the issue of environmental health. Now, ladies and gentlemen, let us all account for the fact that enforcements do not work as they used to. Yes, of course. Right now, immediately when the international courts legally impose these legally binding documents that every country should be held accountable for all of their emissions. Yes, for the first few days, it is surely going to work, just like any other crime. Now, ladies and gentlemen, let us know and understand that as time goes on, are we sure that this measure is going to be working? Ladies and gentlemen, we should know and understand that just like how we have illegalized many other crimes, ladies and gentlemen, crime rate is still not going anywhere. It is still there. Then what is going to be stopping these countries from, even if there are penalties that are there, that exist, that is going to stop them from doing exactly what they have been doing? Obviously, the first few days it is going to work, but it's going to work for the long run, which is why as team opposition we're introducing a measure that we believe is going to be working for the long run, which is what, by bringing in these measures that are going to be empowering these countries to say that this is what we're going to be teaching you, by bringing education, by teaching these people the importance of doing what is right, by teaching these people that what they're doing is actually wrong and it is going to lead to this and that. Because, ladies and gentlemen, yanking away their accountability for themselves and putting it onto the international court to hold them accountable for each and every single thing that they're going to be doing, at some point in time they're going to get used to it. Which is why, ladies and gentlemen, we should be going for a measure that is going to be benefiting these countries for the long run by knowing that what they're doing is wrong, so that they fully understand it. Because a simple imposition, yes, enforcement, yes, it might work, but is it going to work for the long run? Thank you.
Thank you. Thank you very much for your submission. We will now conclude the debate by hearing the concluding statements of the two teams, starting with Durham University for the conclusion in the favor position. You have 2 minutes.
Okay. While the opposition may argue that enforcing legally binding climate action plans could place an undue financial burden on states, particularly developing economies, this perspective overlooks a crucial reality. The cost of inaction far outweighs the cost of mitigation. The economic damages from climate-related disasters like rising sea levels, extreme weather events, and agricultural collapses already cost nations billions of dollars annually. And according to multiple reviews, falling to address climate change would reduce global GDP by up to 20%, while taking strong action to reduce emissions would cost around 1% of global GDP per year. A significant case that underscores the role of international courts in addressing state obligations related to environmental harm is Costa Rica and Nicaragua. In this case, the International Court of Justice emphasized that states must exercise due diligence to prevent significant transboundary environmental damage. A legal mechanism that holds states accountable not only protects populations and ecosystems, but also ensures a fair distribution of the burdens and responsibilities necessary for our collective survival. Without such a mechanism, we're at the mercy of the lowest common denominator, and the inaction of a few ruins the future of all. Precedents like Urgent and Netherlands prove that courts can enforce climate commitments effectively. Legal mandates would strengthen the Paris Agreement's voluntary framework and add legal consequences for non-compliance, making promises not optional. And while historical responsibility matters, climate change is a global emergency requiring universal action. International courts would enforce differentiated protocols and ensure that wealthier nations pay more than the less wealthy ones. International law, while not perfect, but may cause a reduction, and it is much better than total inaction. Particularly the International Court of Justice, it has both moral authority and legal capacity to enforce that. The doctrine of state responsibility holds that states have a duty not to cause transboundary harm. And if we grant international courts the jurisdiction to impose binding climate action plans, we could transform these commitments from political gestures into enforceable obligations.
Thank you. Thank you for your submission. We'll now hear the closing statement in the against position. Team of University of Botswana, you have 2 minutes.
I hope I'm audible enough.
You are.
Okay. So in rebutting what was said by my co-colleagues, I'd like to say, while the idea of international courts having such jurisdiction is appealing for ensuring consistent and committed action on climate change, it presents a significant challenge in terms of sovereignty, enforcement, and equity, as was mentioned by my colleague here. The balance between global coordination and respect for national sovereignty would need to be put in careful considerations. As I had said earlier on, it is like when we involve the international court, it is like whipping a child into submission, and we all know that never works. And I would also like to say that every society has its own way of living, no idea of what's happening in other countries. So for me and for my colleague here, it really doesn't make sense to have the international court deal with matters of other states, but those states should deal with their own matters first. Thank you.
Thank you. Thank you for your submission. This marks the end of your debate. You can all relax now. You're no longer graded after this part. Okay, I will just try to ask you all to see if you can maybe turn your cameras on, and if we can do as much as technical situation allows, at least a short feedback round. Maybe starting with giving the floor to Durham University team. Starting with Ms. Nelligan, perhaps, how did you find the debate? How was the topic when you were researching it? Were you already familiar with the concepts?
I was already familiar with the concepts, and I really enjoyed the topic. I thought it was quite well balanced. When I was researching for both sides, I was able to find a lot of arguments, so I was quite happy with that. And I thought it was an enjoyable and interesting topic and very pertinent to the current societal climate.
Right. Well, thank you very much for the feedback. Ms. Moatse from University of Botswana team, how was it for you? How was the debate and how was the topic when you were researching it? Were you already familiar with the concepts?
In all honesty, just like every other person, I'm going to practice honesty and say I love the government side more than the opposition. And that is what I would have loved more than anything. But it was a great topic to research on. It was a topic that was very close to home because obviously we have a problem with environmental issues at the moment. But it was a very good topic that I enjoyed indulging in with.
Oh, thank you very much for the feedback. Mr. Sluchenkov from the Durham University team, were you surprised by any of the arguments of the opposing team, or were you familiar already with them for your team when you were preparing?
Yeah, I was
this?
actually surprised by some of the arguments by the opponent team, and I would like to thank them. They were a good competition, I would say.
Right, thank you. The same for the University of Botswana team. And Ms. Mugomba, how was it for you? Were you surprised by any of the arguments?
Okay, first and foremost, I'd like to say thank you. It was such an honor to be here, and it was so nice to be participating here, especially that I'm in level 100. I learned a lot, but as she had said, it would have been nice to be in support of, because when we're researching, we got most points on that. But I'm glad we were able to tackle it, and we had a lot of things to say. And while researching in those 5 minutes, we found out that there are actually a lot of things that could be going wrong if we involve international courts. Thank you.
All right, well, thank you very much for the feedback. And just to close off our session, as is a tradition, maybe a quick information that you would like to share with the other team. If they were to visit your university, your city, what would be the first thing you would show them, perhaps? Or a food you would take them to try out? Maybe starting with the Durham team.
Well, we'd probably take them to the castle, which is a Norman 12th century castle. And there's also the cathedral, which is, at the time that it was built in the 12th century as well, it was the tallest in the world. The tallest. So it's quite a historical wonder, and we'd like to show you if you ever come.
Well, sounds like an exciting visit that could happen. Mr. Sluchenkov, is there anything you would like to add, perhaps, as well?
I don't know, I'm thinking regarding food. I think if you've ever heard of northeastern English parmos, they're really nice. So that's the food I would recommend.
Right. What about the Botswana team? If the Durham University debaters showed up in Gaborone for a visit, what would be the thing to do? What would you show them? And perhaps what food you would get them to try?
I feel like if they were to come to my country, the first thing I would do is one, take them to the museum, which will be the very boring part. And two, I'll take them to the best eating spot for Setswana cuisine, and I would feed them bogobe ba lerotse, seswa, and have them eating morogo and pap, and they would be so happy because it is the best food here. And I would generally make sure they have this great time, and probably take them dancing for Setswana, like dancing, because it's kind of entertaining, specifically the choir race. So that is what I'll do them, which is like a quiet in like a very remote area in our country, and I'm pretty sure they would enjoy it.
Right. Do we maybe hear exchange visit in the future, maybe for the two teams? On If you would like to exchange email addresses, do not hesitate to let us know. Our organizing team is happy to connect you. Of course, we also tag everyone on the LinkedIn posts, so that could be another way to stay in contact. Your teams are in this group for the first stage of the Hague Inter-University Law Debate Tournament. Of course, in 2 weeks, you will be meeting other teams, the other 2 universities which are in your group. So this is the one match you are having together. And the 2 best teams from your group will then proceed to the second stage of the competition. Well, on my behalf, I would like to once again congratulate you for your very first debate in this edition, and also for Durham team, your very first debate in this competition in general. So well done, and I wish you all the best for the next matches.
Thank you.
Thank
Bye bye.
Thank you.
Thank you.